What if open source licenses suddenly became a major legal risk for your company? The other day, I came across an article analyzing the evolution of open source licenses and how they are now perceived by courts. For a long time, they were seen as mere permissions, a kind of moral pact where the author allowed you to use, modify, or distribute their code as long as you respected a few conditions. But today, the situation has radically changed. These licenses are increasingly recognized as real contracts, with strict legal obligations and very concrete financial risks in case of violation. This shift has been shaped by several landmark court cases. In Jacobsen versus Katzer, the U.S. courts recognized that ignoring an attribution clause in a free license could be considered a copyright infringement. A few years later, in MDY versus Blizzard, the nexus test was introduced. Only clauses directly tied to the author's exclusive rights, reproduction, distribution, derivatives, could trigger a copyright claim, while others fell under contract law. Then came Artifex versus Hancom, where the GPL was treated as a binding contract, even allowing damages to be calculated based on the price of the equivalent commercial license. Finally, the ongoing lawsuit between the Software Freedom Conservancy and Vizio has opened a new breach. If end users are recognized as third-party beneficiaries of the GPL, they too could bring lawsuits. In other words, the circle of actors able to sue a company could expand significantly. These developments are transforming the risk landscape. We're no longer just talking about an injunction forcing a company into compliance, but about heavy financial damages, potentially calculated on commercial models. Add to this the international dimension. A Japanese, French, or German company could find itself sued in a U.S. court if the rights holder is based there. And with the idea that third-party beneficiaries could act, the number of potential stakeholders explodes, making the terrain even more uncertain. This change directly impacts both creators and users of open-source projects. For a creator, the license is no longer just a document added as an appendix on GitHub. It becomes a true tool of governance and protection, capable of influencing the long-term sustainability of the project. It becomes essential to consider how the license aligns with the chosen business model. Choosing dual licensing, for example by combining GPL with a commercial license, can offer an interesting solution. The project remains accessible to the community while providing a revenue stream. But this choice requires anticipating legal implications and giving users clear explanations of what they can or cannot do with the code. For users, whether individuals or companies, the days of simply grabbing open source code without asking questions are over. The financial risks are real and sometimes severe. The best way to protect yourself is to implement an internal compliance policy, even a minimal one. Inventory all dependencies, equip yourself with appropriate analysis tools, and above all, understand the obligations of each license. This may even mean redistributing modified code when it is under the GPL. Doing this work up front prevents unpleasant surprises and secures long-term use of open source. Of course, this stronger legal enforcement of open source licenses is not without its benefits. In fact, it has some very positive effects. First, it reinforces respect for the rules. For a long time, some companies treated open source licenses as mere recommendations, ignoring them as long as no one complained. Today, the possibility of serious lawsuits changes the game. Actors take their obligations much more seriously. This also gives credibility to authors, who are no longer seen as mere volunteers, but as creators able to legally defend the value of their work. Finally, this rigor improves transparency in software supply chains. Every dependency must be identified, tracked, and documented, which strengthens the overall quality of projects. But there is also a downside. In a stricter legal climate, some companies may hesitate to adopt or contribute to open source projects, fearing costly compliance mistakes. This can discourage spontaneous contributions, especially from small teams or independent developers, without access to specialized legal advice. In some cases, compliance becomes so complex that it hinders innovation. Instead of quickly integrating an open source library, a company may spend months checking licenses, at the expense of speed and creativity. That's why many in the community advocate for a balanced approach. Before resorting to lawsuits, there are other ways to ensure license compliance: educating users, mediating between parties, and actively cooperating to find solutions. The idea is to preserve the spirit of free software, based on sharing and collaboration, while reminding everyone that this sharing rests on rules that must be respected. In this way, the community can continue to grow without descending into a war of lawsuits, and everyone benefits. In Europe, the trend is clear. Open source is increasingly caught in the gears of regulation, with texts like the Cyber Resilience Act and the AI Act. On paper, these initiatives aim to secure software supply chains and regulate AI usage. But in practice, they add a bureaucratic layer that, in my view, risks doing more harm than good. Independent creators and small open-source teams don't have the means to become regulatory experts, nor the time to fill out paperwork just to be compliant. And subsidies often only create an unhealthy dependency on slow institutions disconnected from real-world needs. For me, the true strength of open source lies in its agility, its ability to innovate outside bureaucratic constraints. By stacking regulations and pushing projects toward public funding channels, Europe risks stifling this creative energy. The challenge is not to force open source into a bureaucratic mold, but to give creators the means to remain free, responsible, and supported by their community and users, without the state as a mandatory middleman. As for me, my role is precisely to build a business around open source, tackling these challenges head-on. I comment on these developments, share my experiences, and break down trends so that you too can create profitable and sustainable open source projects. If you want to go further, subscribe, comment, and share. You'll find the keys to turn open source into a strategic opportunity, not a hidden risk. Subscribe to my Patreon to access my detailed methods and plans. Like, subscribe, comment.